Well, the first point to make is that it's a separate decision. So the first decision by Border Force was quashed because it was found to have been made unlawfully, unreasonably, and that's unlawful. It's beyond power. What the minister is considering is actually making a fresh, separate decision. And under the section that gives the minister personal discretion, there are fewer avenues of appeal. So Mr. Djokovic could not appeal to the Administrative Appeals Tribunal. All he could do is seek judicial review in the courts. And what the courts do in judicial review is determine whether the power has been exercised lawfully. So it would all depend on how the minister exercises the power and whether he does so in a manner which is lawful according to law. And I just emphasise that the discretion that the minister has is very broad. So realistically, unless the minister makes a procedural error, doesn't comply with the terms of the Act, or unless the decision really has no basis, then Mr. Djokovic is unlikely to succeed. The minister here is considering exercising a personal discretion to cancel a visa. In the refugee cases, we'd be talking about a different discretion, which is still a very broad discretion, to grant a visa in circumstances where it's been established that the people do not meet the criteria for a visa. So the minister the ministers have a large number of very broad discretions to both give people visas and to cancel them. So it's undoubted that the minister has the power to exercise a personal discretion to grant the Biloela family visas and to end their detention. That is undeniable. The reasons why he has, or she, in the Minister for Home Affairs, have chosen not to do that is, I assume, entirely political, based on whether they think it is a good idea politically to do so, and that's, in the Act referred to as in the public interest.